Good afternoon and welcome to, or thank you for attending the seminar. The topic that I'll be dealing with today is restraints of trade. We're going to do a general overview of restraints of trade in contracts of employment and have a look at the way in which courts have recently interpreted or enforced restraints of trade. Let's get started. The statutory background to the enforcement of and the drafting of restraints of trade in contracts of employment is actually quite interesting. And as you can see, I've mentioned a number of pieces of legislation here, which should be familiar to you as labour practitioners, human resources practitioners, or general counsel. You would certainly have come across these pieces of legislation in dealing with any employees or workforces. So the Labour Relations Act 66 of 1995, you're all aware of that, creates those general obligations to not unfairly dismiss an employee, not subject an employee to unfair labour practices, etc., etc. Very, very important piece of labour legislation. Then a more administrative daily piece of legislation, the Basic Conditions of Employment Act, deals with annual leave, sick leave, etc., etc. And then, of course, the Employment Equity Act, which we've heard something about and we'll hear some more about a little bit later. The interesting thing to understand and realise in relation to these pieces of legislation, and in fact any other pieces of legislation which you ordinarily deal with in a labour or an employment contract or context, is that when it comes to restraints of trade, these pieces of legislation have absolutely nothing to do with restraints of trade. And that's quite important to know, because although labour is generally very heavily regulated by these pieces of legislation, when you have a look at the contract of employment and when you have a look at the restraint of trade undertakings contained in a contract of employment, we're actually dealing purely with contractual issues. There aren't really any labour statutory requirements or considerations which come into being. So we're really having a look at it and focusing on the particular provisions of the contract of employment entered into between the parties. Flowing from that, if we have a look at the contract of employment, and again, understanding that ordinarily that contract of employment has input and is dealt with very extensively by those pieces of legislation, you ordinarily have to look at the contract of employment in the light of the Labour Relations Act. For example, can't simply dismiss an employee because of a breach of contract. You've got to comply with the Labour Relations Act. The contract of employment is still at its heart a contract between the parties. So general contractual principles definitely govern the circumstances in which a restraint of trade is formulated between the parties and is potentially enforced by the courts. So the first starting question is there an agreement between the parties in relation to a restraint of trade? And that has to be contained in the contract of employment. If there is nothing in the contract of employment, then effectively there is no restraint of trade. Because again, the Labour Relations Act says nothing about restricting a party post-termination of employment in relation to a competitive activity. The Basic Conditions of Employment Act says nothing as well. If there's not a contractual provision in the contract of employment between the parties, then there will not be a restraint of trade which is enforceable between them. We're going to have a look a little bit later at this case, Warwick Wealth. I mention it below simply because there's quite a nice statement which is made therein, which says that there's no dispute that Anderson, the particular employee or former employee in that case, there was no dispute that this person had signed an employment agreement which incorporated a restraint of trade clause. Therefore, there exists a valid, binding, and enforceable restraint agreement between the parties. Again, just applying general contractual principles, if there is a restraint of trade provision or a clause, you'll have a look at that contract, the court will have a look at that contract. If it exists, they'll determine later whether or not it's enforceable for different reasons, but the starting point is always, is there some kind of a contractual provision or undertaking in the contract of employment? If yes, move to the next consideration. If there's nothing, there's generally going to be very little which a former employer can do in relation to its employees who are potentially acting anti-competitively. Again, a general contractual principle in South African law is that restraints of trade are generally prima facie enforceable in South African law. This is potentially quite different from some other jurisdictions. We very often get questions from foreign law firms where they say, in our particular jurisdiction, restraints of trade, anti-competitive, restrictive covenants are not necessarily prima facie enforceable. You have to make out a very, very solid case to the court that you are entitled to the enforcement of a restraint of trade undertaking. Generally, the onus is then on the party to convince the court that you should allow a restraint of trade undertaking contained in a contract of employment to be enforced. South African law, slightly different. It's developed over time. It's developed through case law. Generally, the South African courts say, is there a contractual undertaking in the contract of employment? If yes, that should generally be enforceable. Referring there to Chief Justice Rabi, previously had held there's nothing in our common law which states that a restraint of trade agreement is invalid or unenforceable. Again, South African courts look at it, look at the contract of employment, look at the papers between the parties. If you're able to plead and point to a particular contract or a provision in a contract of employment which purports to contain a restraint of trade, prima facie that is generally enforceable. That approach is on the basis of the general maxim in South African law. These are contractual principles. Again, we're definitely within the sphere of labor relations. We're definitely dealing with employee relations. But again, you're not within that statutory framework of the Labor Relations Act. You're not within the framework of the equity and the fairness provisions of the Employment Equity Act. You're looking now generally at very strict contractual provisions and general conditions of contract, insofar as it's a contract of employment between the parties. So that Latin phrase at the top there, pacta sunt servanda, basically just means that agreements should generally be honored. And South African courts will generally try to enforce undertakings and agreements between the parties unless there's some kind of a public policy or other reason not to do so. This case, Warwick Wealth, is quite useful. And again, we'll talk about it in a little bit more detail a little bit later. But one of the quotes which comes out of that is this nice quote which says, "It's in the public interest that agreements entered into freely should be honored, and that everyone should, as far as possible, be able to operate freely in the commercial and professional world." So again, looking at the contractual principles, if there's a contractual undertaking in a contract of employment, which says that there's a restraint of trade, generally that's going to be binding between the parties. Let's have a look in a little bit more detail at what exactly restraints of trade are and what they comprise, because the wording can in certain circumstances be considered to be a fairly generic term. It does have certain meaning for labor lawyers, it does have certain meaning for practitioners, but it can also be quite generic. I mentioned earlier as well that we sometimes receive queries from foreign law firms, from foreign clients, about the enforceability of these kinds of restraints of trade. Sometimes they talk about these as restrictive covenants, which can be quite an interesting way of thinking about these contractual undertakings, in that it's an undertaking or a covenant, some kind of an agreement between the parties, which in some way restricts the employee from acting in a particular way. So a restrictive covenant is a fairly good, useful term to think about what restraints of trade, as they refer to in South African law, encompass generally. A restraint of trade is a very particular thing. So when you think of a restrictive covenant, you're generally thinking about a wider basket of undertakings in terms of which an employee agrees not to act in a particular way, to be restricted from acting in a particular way. So restrictive covenants generally, and what we do refer to in South Africa as restraints of trade, can generally comprise confidentiality undertakings, non-solicitation undertakings, actual non-compete undertakings, and then what we refer to as non-dealings undertakings. So let's have a look at each of those in a little bit more detail. So restrictive covenants or restraints of trade in respect of confidentiality. Confidentiality is generally a fairly simple contractual undertaking to provide for. And this is actually one of the slight deviations from the general principle that if you don't have a contractual provision in a contract of employment, then you don't have any protection. Because confidentiality is also recognized by South African courts as being capable inherently of protection for an employer, by mere virtue of the fact that information or trade secrets or intellectual property or any information that an employee comes to be aware of in the course and scope of their employment with the employer, because there's a value to that, because that should be capable of protection in and of itself, then there's actually a common law understanding and there's a common law protection of that confidentiality by South African courts. So although you very often see in contracts of employment that there are very specific and very detailed definitions of what could constitute confidential information, and then there would be an undertaking for the former employee to keep that confidential information confidential and a trade secret. If you don't have a contractual undertaking in a contract of employment in relation to confidentiality, you don't completely lose protection. It could still be that the employer is able to demonstrate that because the information is confidential, prima facie, by its very nature, it should be capable of protection. And you wouldn't necessarily have to appeal to a contractual clause in an employment agreement to go to court and say the employer has breached this particular clause in this contract of employment, and I'm therefore seeking the protection of the confidentiality of the previous employer's information. You can rely upon a common law right to say the information is in and of itself confidential, the employer is in possession of that confidential information, and it should be capable of protection. You know, as an example, if the employee becomes aware of inherent trade secrets, we talk generally as an example, if the person has the formula for Coca-Cola, by mere virtue of the fact that he leaves the employ of Coca-Cola, the employer, he shouldn't be able to take that information and pass it on or use it in a competitive sphere. So again, there's a common law protection in relation to confidentiality. Let's have a look at the next one. So non-solicitation undertakings, you're now entering the realm of the pure contractual undertakings. Non-solicitation is an area in which if you don't have a contractual provision in the agreement between the parties, then you do not have any protection. And the employee would be able to freely solicit anybody post the termination of the employment relationship. So non-solicitation, it is what it sounds like. It'll be an undertaking that you as a former employee cannot solicit any employee who remains behind in the organization that you've just left. And you cannot also potentially solicit any customers, any clients, any suppliers or any service providers, generally any kind of a third party with whom the former employer has commercial dealings. You're not going to try and solicit them to terminate either the employment relationship with the former employer or to terminate their contractual relationship with that former employer. And again, you would have very specific provisions in the contract of employment undertaking not to solicit employees, solicit customers or clients. We're going to have a look a little bit later in relation to pure non-competes, the reasonableness test, which is applied by the court. And generally, when you have a look at the reasonableness of restrictive covenants and whether or not the courts would be willing to enforce those restrictive covenants, you're looking at things like the time period post the termination of the employment relationship for which those restrictive covenants are sought to be enforced. And you're also looking at the geographical area within which those restrictive covenants should apply. Those become very important when you're dealing with non-competes and to a certain extent non-dealings as well. Non-solicitation, because you're simply saying don't mess with or interfere with existing relationships that the former employer has, again in relation to its existing workforce or the body of its commercial third-party service providers, it becomes more an issue of the time period for which you want that non-solicitation to run. But a geographical area, it's not unimportant, but it's not as important, for example, when you deal with non-competes. Non-competes then as a restraint undertaking. This is where generally South African lawyers, labor lawyers, human resources practitioners and employees will really think of the restraint of trade. When that term restraint of trade is dealt with, and when you look at cases in the labor courts, generally when you're looking at a restraint of trade, you're thinking of what's actually a non-compete. So this would be some kind of a contractual undertaking in an employment agreement whereby the employee undertakes post the termination of the employment relationship not to become involved in a business which is competitive with the previous employer. It's an actual non-compete. Again, restraint of trade, you're being restrained as a former employee from being involved in a business or a trade or any kind of economic activity which competes with your previous employer. You can see it's different from the confidentiality undertaking. And again, just to emphasize, the confidentiality undertakings do have common law protections. The non-compete is different from the non-solicitation undertakings. Again, don't solicit any employee, don't solicit any existing service provider to terminate their employment relationship with the previous employer. The non-compete is don't be involved, don't become employed, don't set up a business, don't become a consultant to any entity which acts in competition with your previous employer. So that's generally a far broader, far more restrictive covenant or undertaking which can be given by an employee. And this is why the courts will try to balance the enforceability of those non-compete restraint of trade undertakings to ensure that there's fairness between the parties. We're going to have a look a little bit later in relation to how the court balances those various factors. Let's have a look at one more additional element of a restrictive covenant, just so we can understand fully exactly how restraints of trade or restrictive covenants can work as a total package of undertakings to try to protect the proprietary interests of an employer. So the last one then is what we call or refer to as a non-dealings undertaking. It's a restrictive covenant. It's also technically a restraint of trade, but it's slightly more specialized. It's slightly more focused than the general non-compete. Again, the non-compete would say, don't become involved in any business which competes with your previous employer. The non-dealings clause, the non-dealings undertaking, slightly more focused. It would act, for example, to say, you as the former employee should not be involved in, provide any services to, or have any dealings with any clients who were clients of your previous employer. So you can immediately ring fence a specific set of clients. You would be able to either through making it out in the pleadings or knowing, for example, from an annexure of specific clients which might be attached or specified in the employment agreement dealing with the non-dealings undertakings. You might have a list of very specific clients. The former employer would identify third parties A, B, C, D, and E. Those are my clients as at the termination date. I currently provide services to those clients. I do not want my former employee to leave me and to start providing services to those clients. That would potentially be competing with me, but it's very specifically competing with me by having commercial economic activities provided to a specific set of existing clients. So non-dealings, don't deal with any of the former employees' client base. Hopefully, after having had a look at those 4 different types of restrictive covenants, and again, it's confidentiality, very specifically protecting the confidential information of the employer. Then the non-solicitation, don't solicit anybody to terminate their existing relationships with the former employer. Non-competes, the more generic, more general, more widespread undertaking. Don't be involved in a business which competes with the previous employer. And then the non-dealings, don't be involved with any clients of the former employer. The question is, how reasonable are those restrictive covenants? How reasonable is it to require a former employee to not involve themselves in all of those types of activities? Remember that the first point that we made when looking at restraints of trade in South African law is that they are prima facie enforceable. If there is a contractual undertaking in the agreement between the parties, then the South African courts will ordinarily say you should be bound by and the party should adhere to those contractual undertakings. However, because it is restrictive, they're called restrictive covenants, it's restrictive on the ability of the former employee to conduct himself in his absolute discretion in any industry and any trade that he would want to. And very often we take into account the fact that the employee might have a particular length of service, length of experience, a particular set of qualifications in a particular trade or industry or area of service. Very generally, the employee would only want to move from one employer to the next in that same industry. Is it reasonable to require an employee to undertake not to be involved in a competitive activity if, for example, that competitive activity is service-wide? So the courts accept the fact that there is potentially an unfair, unreasonable restriction which can be imposed upon an employee when they undertake in a restrictive covenant not to be involved in any of those restraint of trade activities. Is it fair for them to be able to do so? How long should they be restricted? Again, the general principle is if you sign the agreement, you should adhere to the agreement. However, like it says over there, the courts will invalidate and refuse to enforce agreements which are contrary to public policy. So that's similarly in relation to any agreements in relation to restraint of trade or restrictive covenants. So when a South African court, which is tasked with enforcing any restrictive covenant or restraint of trade undertaking, they have a look at a number of things. First of all, there are the rights of the employer not to be exposed to unfair competition. Those are generally thought of as the proprietary rights of the company to conduct its business in a way where it's not exposed to unfair competition, especially in circumstances where there may have been training, there may have been client relationships, there may have been information which the former employee is exposed to, or which that employee is able to take advantage of by virtue of the fact that he's been trained, he's spent a particular amount of time within the former employer's organization, he's formed client relationships, and now he's going to be able to go, he's going to be able to leave, and he might be able to use that experience. He might be able to use those client relationships. He might be able to use that information to the benefit of the new employer and therefore unfairly compete against the former employer. So the previous employer, any company, has got a right to protect its proprietary interests, to not be subjected to unfair competition. Competition in the normal course, absolutely fine, of course, but there are certain elements which the courts recognize it could be unfair if an employee simply steps into the shoes of the new employer and unfairly competes because of all of the advantage that they've received from the previous employer. Could be unfair. On the other hand, you've got the constitutional right. So the fundamental primary constitutional right of the employee to conduct a free trade. That is a constitutional right. And you can see the tension between those two elements. I don't want my former employee to go and compete against me. I don't want him to go and work for a competitive business. That could harm my proprietary interests. However, what does that mean for that employee? Does he have a right to choose his trade freely? Can he work for who he wants? How does it restrict him from being involved in a trade or an industry that he has the training and the experience in? Are those elements fair? The court is tasked with balancing those two competing interests. This is interesting as well, and this is something which we get very often from all of our clients overseas, from law firms overseas. They say to us, yes, certain foreign jurisdictions, they may or may not allow restraint of trades. They may have different approaches to the enforceability of restraint of trade in terms of being prima facie enforceable. But one of the questions we get all the time is, do you have to pay the employee who gives a restraint of trade undertaking? Do you have to pay them any consideration for that restraint of trade? And at least in South Africa, the answer to that is no. There is absolutely no requirement for a restraint of trade to be enforceable, for a court to grant an order compelling the employee to comply with that restraint of trade. There does not have to be any money paid to the employee, either during the employment relationship or during the period of the restraint of trade. The primary issue which the courts are looking at is whether or not the former employer has got that proprietary interest which should be protected so that there's no unfair competition. It's not whether or not you've bought the restraint of trade, it's whether or not you've got a protectable interest. That's the primary consideration when looking at it from the employer's perspective. So restraint of trade consideration, not a requirement in South African law in order for a restraint of trade to be unenforceable. Having said that, there's nothing which would prevent some kind of consideration being paid. It doesn't invalidate the restraint of trade if money is exchanged as a result of that. It could also be taken into account by the courts when looking at the fairness of the enforceability of the restraint. Is it fair to restrict the person from being employed in a competitive industry? Well, it's slightly more fair because in the particular circumstances, the previous employer is in fact going to be paying that person money during the period of the restraint. A court may, in those circumstances, consider that it's less punitive, it's less restrictive, it's more fair on the employee for money to exchange hands, but it's not a requirement in terms of South African law. Again, having a look at then the reasonableness and the balancing act which the courts conduct in having a look at the various interests. They have a look at, is there some kind of a protectable interest in the part of the employer? They have a look at, does that particular employee have any kind of particular advantage which they have obtained during their employment with the employer that could be used in the hands of a new employer to compete unfairly against the previous employer? Are there trade secrets? Are there confidential information at hand? Are there client relationships which the former employee has built up in the course and scope of performing their services? Is there some kind of an interest which is capable or should be protected to allow the former employer to not be unfairly competed against? When you then have a look at whether or not it's fair or reasonable to enforce a restraint of trade undertaking in relation to an employee, these aren't the only two factors, but generally you have a look at whether or not the geographical area of those restrictive covenants and the time period for which those restrictive covenants are sought to be enforced are generally fair. When a contract of employment is drafted, when the restrictive covenants are drafted, it's also quite important to bear these issues in mind. We're going to have a look a little bit later at how the courts can try to get a restraint of trade undertaking which it feels isn't quite reasonable into a reasonable state, but there is a limit to which the courts can be pushed in asking to redraft the contract between the parties. So it's quite important that at the outset of the employment relationship, when the contract of employment is entered into, or when a restraint of trade agreement is entered into in the course and scope of employment, that these geographical area and time period issues are taken into account to ensure that, again, prima facie, it looks as if the restrictive covenants are generally fair and reasonable. So what you would want to have a look at is the geographical area. For example, if you were, as a former employer, to try to impose a restraint of trade against an employee on a worldwide basis, and looking at the time period for the remainder of the employee's life, that would absolutely be unfair. There is no court which would enforce a worldwide lifetime restraint. They would simply say, for example, do you conduct business in every single jurisdiction in the world? And what is the point of restricting the employee from competing against you for the remainder of his life? Surely there's some kind of a reasonable time period after which the employee can re-enter the workforce. And although he may then work for a competitor, the competitive disadvantage which he brings by working for a competitor is somehow sterilized or neutralized or diminished. After a period of time, the industry has changed, technology has changed, the client relationships have changed, potentially the way in which services are provided have changed, the business is different, and he can't unfairly compete against you for those reasons. So time period is generally quite important. Certainly a lifetime restraint of trade is never going to be enforceable in South Africa, and certainly a worldwide geographical area is never going to be enforced by a South African court. So you have to balance those issues. Generally, what you're having a look at is try to restrict the geographical area in which you're seeking to enforce, in particular, the non-compete and the non-dealings to the actual physical areas within which the former employer conducts a business. So, for example, do they conduct business in South Africa, but not outside of South Africa? It might then be reasonable to restrict the geographical area to South Africa. It can become even more focused than that. Does the employer conduct business in every single province in South Africa? If not, would it be fair to restrict the employee from performing services, for example, in the Western Cape, when the employer is located in Johannesburg and doesn't have business interests in the Western Cape? That shows the protectable interest concern as well. Is there a protectable interest in the Western Cape if the employer does not conduct business activities in the Western Cape? How can it be unfairly competed against in the Western Cape if it only services the Johannesburg area? Surely in those circumstances, the employee should be allowed to go and work for a competitive entity in the Western Cape, because it's not taking away any business from an employer which acts and operates only in Johannesburg, only acts in Gauteng. Those are the kinds of considerations which you look at when you look at the geographical area. You're also starting to realize, you're also starting to understand that when you have a look at the drafting of these restraint of trade considerations, you have to have a look very particularly at what the former employer's economic activities are, what, for example, their footprint is in terms of a geographical area, what kind of competitive activities or functions do they perform, what is their business, and then what is the reasonable time period that you should attempt to restrict an employee for. I mentioned earlier as well that certain industries can move quite quickly, technology develops quite quickly, some of them are slower, a little bit more conservative than others as well. Generally, if a case is able to be made that the industry is quite fast moving, within 6 months to 12 months time, for example, in the IT industry, there's new technology, there's new software, everything has changed, the environment has changed. It might be reasonable in those circumstances to have a shorter rather than a longer restraint of trade time period. Generally, however, as a rule of thumb, you're not going to be able to impose 5-year restraints of trade against a person. And generally, depending on the seniority of the person, the experience of the person, the extent to which they have client contacts, to which they have relationships with service providers and would be able to take those relationships away. So how important they are within the business, you can generally motivate for a longer rather than a shorter time period, but that time period has to be reasonable. So when the courts are tasked with enforcing, they have a look at those various elements and they adopt an approach of what they call holding the blue pen. Now, this is in relation to having a look at the contract in which the restraint of trade undertakings are provided. And again, they say prima facie, those should be enforceable, but having a look at them, they have to be reasonable. If they contrary to public policy, if they unduly or unreasonably restrict the employee, if they go too far, then they should be kicked out completely. On the other hand, if there are contractual provisions which allow certain portions of those restraint of trade undertakings to be severed down, the court will actually have the contractual entitlement through that agreement between the parties to have a look at an element of the restraint of trade that it doesn't feel comfortable with, to sever them down and to come up with something that it feels is reasonable in the circumstances to achieve that balancing act. However, there is a limit. So what the court says is that they will hold the blue pen. They will strike out 1 or 2 words. They will amend and change 1 or 2 things, but they will not redraft the entirety of the agreement. So, for example, if you were to have a contractual undertaking to say, you're restricted on a worldwide basis, you're restricted for the rest of your life, but to the extent that the court isn't happy with that and doesn't want to enforce that, there's severability provisions, and the court can come up with whatever agreement it feels is necessary or reasonable in the circumstances. The court would say, you're essentially passing the buck on to me as the court to draft the agreement between the parties. I can amend it slightly, I can change things with a blue pen, but I'm not going to redraft the agreement completely as well. Again, you can see there that quote, the general approach to severability is that a party should not be allowed to draft such an encompassing contract which on its own wording is plainly unenforceable for being overbroad, again, worldwide restraint for the remainder of the person's lifetime, and then seek under the guise of a severability clause to request a court to develop what is in effect an entirely different contract. And again, the principle is an overbroad restraint is not enforceable and cannot be saved by a severability clause. So in particular, when you're drafting a contract of employment, when you're drafting restraint of trade undertakings as well, you need to look very particularly at who is the person who I'm seeking to restrain, what is my business, what is reasonable in the circumstances, and try to come up with some kind of a geographical area and a time period that the court should feel generally comfortable with, that you can motivate in your papers to court when you're seeking to enforce the restraint, that this generally is enforceable. And if the court is a little bit unhappy with 1 or 2 elements, they can hold the blue pen and they can sever certain elements down. For example, if you were to say, we think that the time period of 24 months is reasonable, you might get the court saying, I'm uncomfortable with 24 months, but I'll sever it down to 18 months. That would be within the realms of reasonability. Let's have a look at a particular couple of cases. So the one which has come out recently is Warwick Wealth. And this is quite an interesting case. You saw that we referred to it a little bit earlier, setting up some general principles in relation to the enforcement of restraints. And these are quite recent cases. This is a 2023 case in which Warwick Wealth wanted to enforce a restraint of trade. Very generally, what happened in that regard is that the court was quite happy to accept that prima facie there was an employment agreement which incorporated a restraint of trade clause. And the court then said, Therefore, there exists a valid and a binding and enforceable restraint agreement between the parties. When it then had a look at all of the elements of enforceability, reasonableness, it had a look and it said, yes, there's a protectable interest. Yes, it's prima facie clear that the former employee will be working for a competitive entity. And in those circumstances, it would be fair for the court to actually enforce the restraint of trade. It's interesting in this case as well that the time period of that particular restraint, and which the court felt happy to enforce in the circumstances, was a 3-year restraint. Generally, that might be considered to be slightly longer than usual. As I indicated, if you were to draft a restraint of trade provision, you would generally want to look at between 18 and 24 months. But it is possible to make out a case that because of seniority, because of the particular unfair advantage which a particular employee could take to a competitor, you can make out a case for a slightly longer restraint. The next case, which is also quite recent, is a 2023 case of Wheelwright. And in those circumstances, there was also a 24-month restraint, which the court was prima facie very happy to enforce. This is quite interesting as well in that it demonstrates that restraints of trade are purely contractual undertakings. Again, going back to the introduction, is that the Labour Relations Act, the Basic Conditions of Employment Act, any other pieces of labour legislation don't really have anything to do in relation to formulating and enforcing restraint of trade undertakings. So in Wheelwright, prima facie, there was a 24-month restraint, which was enforceable against the employee. The courts were quite happy to enforce that. But at some point in time, the parties had entered into a settlement agreement, which had a very generally broad settlement clause. The court was happy to accept that actually what the parties were attempting to do by entering into the settlement agreement was settle a dispute between the parties about the circumstances of the termination, the dismissal of the employee. But because that clause had been formulated quite broadly, it talked about the settlement of all disputes. It talked about superseding and replacing all agreements between the parties. Because the restraint of trade was an agreement between the parties, and there could have been, or there was in fact a dispute in relation to the enforcement or the breach of that restraint, the courts felt that unless the parties had specifically excluded the restraint of trade undertakings from the ambit, from the scope of that settlement agreement, then the intention must have been to settle any and all previous agreements. So it's a purely contractual principle. The restraint of trade was created through the contract, and the restraint of trade was settled through the contract. So in these circumstances, the court said you cannot enforce the restraint of trade undertaking against the employee because it has been settled under the settlement agreement. One final case just to mention, which we weren't able to include on the slides because it is actually very recent, but it also just goes to demonstrate the way in which the courts have a look at the prima facie enforcement of restraint of trade undertakings. It's the recent case of ShopRite Checkers and Clicks Retailers, also a 2023 case coming out of the Western Cape Division, in respect of which an employee wanted to move from ShopRite Checkers to Clicks Retailers. The court in those circumstances was able to have a look at the facts of the case. It also does that generally on an urgent basis, because when the employment relationship terminates and the employee seeks to move to the new employer, the competitive employer, and because the post-termination restraint of trade time period would start running from the termination date, you have to move on an urgent basis if you're seeking to enforce the restraint. So generally, these restraint of trade cases are heard by courts on an urgent basis. The court was happy in this case to do so. It had a look at all of the public interest issues, public policy. It had a look at whether or not the employee was young enough to be released from the restraint, which they found it wasn't. It found that the second respondent, Clicks, was definitely a direct competitor of the applicant ShopRite. It found that there was a clear potential breach of the restraint by mere virtue of the fact that the employee would move from ShopRite to Clicks. And it found that on that basis, because there had been a restraint of trade agreement between the parties, it said the enforceability of contracts is essential both for commerce and fair employment practices. And in those circumstances, it found that signed a restraint of trade agreement, undertook not to compete or become employed by a competitive entity as well. Prima facie, it looked as if you were going to do that, the restraint should be enforced. So in general and in summary, it's clear that the South African courts are willing to enforce restraint of trade undertakings, provided that the work has been done in the contract of employment to make sure that those contractual provisions exist and are fair and are reasonable. Again, to sum up, what does this mean for employers? If you have a contract of employment and there are no restrictive covenants, there are no restraints of trade, you don't have anything. You cannot rely upon the Labour Relations Act. You cannot rely upon any other piece of employment legislation. Restraint of trade undertakings must be contractually formulated. If there's going to potentially be a breach after the termination of the employment relationship and the employee becomes a former employee, then enforcement takes place on an urgent basis, generally on motion proceedings, on the papers, relying on and showing the court that there are contractual provisions setting out the non-compete undertakings. And again, the final point is the courts will always have the final say. Yes, there's an agreement. Yes, the agreement is prima facie enforceable. Yes, parties should be bound by the agreements that they sign. But is it fair? Is it reasonable in the circumstances? And they balance up the interests of both of the parties on the elements and the factors that we've just had a look at in order to see whether or not it's possible and reasonable to enforce the restraint. If it's reasonable, if it's possible, they will enforce the restraint and the employee will not be allowed to act in a way which places them in breach. Thank you for the time. Appreciate your attention.